Yeah. Um, and then if we look what the judges say, the field report the respondent conducted was on 12th of September 2018. The income tax period is in issue is 16 to 17. The prices of tea is not static, so the judges raise the issue. One cannot use the price of the tea in September 18 to ascertain whether the price from April 16 to March 17. And I'm not sure if this is what the tax authorities did, but it seemed to be implied here. The prices at the auction market in September 2018 may have increased. The said inspection report is not signed. So first of all, it says that the prices may have increased, but without really looking at market statistics, whether they have or not. One would assume that those statistics are available in Uganda itself. But it does criticize the report. It says the report was not signed. Furthermore, it does not disclose whether unrelated companies and their officials, which unrelated companies and their officials the respondent interacted with, and that's the tax authorities, and which is strange because, I mean, they do list the companies that they've looked at. And then it says no sales invoice of unrelated companies are attached. Further, the interview was not representative of the local leaf market. Only 5 outgrowers were interviewed, but one assumes that these were the largest 5 outgrowers, and they may also have been of comparable size, one would assume, of Bondo tea estates, but the court doesn't say anything about that. And then the court continues to criticize and says the minutes of the stakeholders show that there are more than 5 tea factories in the Toro tea growing region, which rely on hundreds of individual outgrowers for their supply of green leaf. So the court is very critical of the tax authority's study. It says the respondent's representative ought to have interviewed outgrowers selling green leaf to Kajura Tea Company to establish what price they were charging. The representatives only interviewed outgrowers selling their green leaves to Rescare Growers Tea Company, McLeod, as we talked about, Russell, Mabale Growers, etc. Right? If they have interviewed the others, they would have been able to establish the difference between the applicant's sales price and that of the other outgrowers, whether or not that was due to distortions from other factors like transport costs or the quality of the green leaf. The report does not state the locations of the fields of the 5 to determine the distance between the fields and the tea factories. The report does not show whether the outgrowers incurred additional expenses, such as transport. The respondent's failure, in other words, the UTA's failure to take these factors into account substantially affect the credibility of the field inspection report. And these are fair points raised by the judge, right? And the judges, I should say. And to give you an idea, here is a map of the relevant area of Uganda. You can see there's a 400-kilometer difference. It seems like on both cases, Bondo in any case is in the shadow of some mountains or something, because it's the typical graphical map. And then the other outgrowers that they were looking at were all in Hakibale, Mabale, and Kienjojo. That is where our McLeod Russell company was situated. So obviously distance does matter. I don't know how much 400 kilometers would matter in this particular case, but it could be that climates were very different and nothing was said about that. And the court comes to the conclusion, it says, from the evidence before us, we have failed to find sufficient justification for the adjustment by the respondent of the applicant's sales price. We accordingly find that there was no under-declaration by the applicant of its sales of green leaf tea to the Kajura company. But it raises an important question. Why were the judges not equally critical of the taxpayers' January 2015 numbers? And why did they not look critically at the taxpayers' claim to internal comparables, which the taxpayers, according to the judgment, never have produced, right? One would assume that if the judgment was balanced, that it would be as critical of lack of information from the tax authorities side as it is of lack of information from the taxpayer side. But that does not seem to be the case here. And then there's a last issue that there is an interesting one. I don't think it is correct what was argued here, but it's still noteworthy. And this is whether the fair market value of an item is the same as the arm's length price. I mean, this is the way the taxpayer presented it, right? The applicant contended that the adjustment to the average market price to goods between the applicant and its parent by the respondent was not lawful. The applicant submitted that sections 51 to 69 of the Income Tax Act provide for the application of fair market value, while sections 23, 52, and 53 and 90 provide for the application of an arm's length value. So it says there are differences here, right? The applicant submitted that while the Income Tax Act provide for the application of both fair market value and an arm's length value, as if these are two different things, for the purpose of determining the price between independent parties under the concept of a willing buyer-seller, willing seller, considerable differences existed between the two methods. The arm's length principle called for a subjective valuation by establishing comparing uncontrolled transactions. The fair market value principle requires an objective market-based valuation. And this is an interesting question that arises. If we look at the parts of the Ugandan Income Tax Act that the taxpayer refers to, you can see Part 6 deals with gains and losses on disposal of assets. That's sections 51 to 69. And then Part 7 deals with miscellaneous rules for determining chargeable income. Part 8 deals with persons assessable, so income for individuals and for partnerships and partners. So this is all kind of the taxable objects and how you determine the income from that, right? And then the applicant also submitted that section 91 of the Income Tax Act provide that the Commissioner may allocate income between related parties so as to reflect the income realized in an arm's length transaction. The applicant argued that Regulation 3 of the Income Tax Act, the regular transfer pricing regulations 2011, provides that an arm's length transaction refers to a transaction between related parties, the results of which are consistent with the result that would have been realized in a transaction between independent persons dealing under the same conditions. Now this all seems fair. And if you look at Part 10 and Section 90 that the taxpayer referred to, Section 90 is in Part 10, which deals with anti-avoidance measures, and it deals with transactions between associates. And associates is the term that's used for related parties, among others, in the Ugandan Income Tax Act. But it does raise a number of questions. I mean, the first one is, would Part 10 not be equally applicable to all the other parts of the Income Tax Act? Because Part 10 is just anti-avoidance. I mean, clearly, the anti-avoidance legislation must be applied to the taxable objects and the taxable subjects. So it is simply legislation applying on top of the others. So you can't say that Section 10 stands by itself and that cannot have anything to do with it's dealt with in Section 6 through 8. I'm taking a guess here. I'm not a Ugandan lawyer. And there's also the issue that the court then goes on to say the term arm's length transaction is not defined in the Income Tax Act, and then surprisingly it reaches to Black Law's Dictionary 10th edition, and it says how that defines arm's length transaction. But one wonders, why did the court not look at the transfer pricing guidelines, or if they argue that Uganda is not an OECD member, why don't they look at the UN practical manual? I think these are fair questions to ask. I also think the taxpayer plays a bit of a word game here, because it confuses not fair market value with arm's length value, but what it confuses is the average market price with the fair market price. I think fair market value and arm's length value is one and the same thing, and both are dependent on satisfying the 5 comparability factors, right? And I do agree that the average market value can be very different from an arm's length value, and maybe that's what the tax authorities did here. Maybe they did take the average market value, although they did have a pretty wide range which they were prepared to look at, 500 to 700. They adjusted to the bottom of that range at 510. So I'm not sure that one can accuse the tax authorities of using the average price, because according to to their calculations, that would have been 600. And it's something that maybe the court could have dealt with. And also, when one looks at the law referred to by the taxpayer, and again, I'm not a Ugandan lawyer, but thank God, thank God, I would say it in the idiomatic expression here. The Ugandan law is in English because that's an official language. If we look at what the cost base is, it says the cost base of an asset acquired in non-arm's length transaction, in other words, in a related party transaction, is the market value of the asset at the date. So what they say is the market value of the asset is effectively the cost base of the asset. But then they go on to say special rules for consideration received, where an asset is disposed of to an associate, the disposer is treated as having received the greater of the cost base or the fair market value of the asset. Now, these two articles seem to contradict each other on what the fair market value of the asset is, but I think it's to be read so that if there is no fair market value, then the fair market value is deemed to be the cost base. And if there is a fair market value, then the fair market value is indeed the actual fair market, or should that be higher, the cost base of whatever is transferred. Of course, that's not necessarily an arm's length price, but that's what Ugandan law says. And then Section 90, that the taxpayer referred to, the Anti-Violence Act, says in any transaction between taxpayers who are associates, the commissioner may allocate income between taxpayers as is necessary to reflect an arm's length transaction. Now again, I don't see, how this makes an arm's length price different than a fair market price under Ugandan law. I think that was a bit of a play of words, which were maybe not totally correct. Anyway, that is what I have for you this week. As I say, I don't think this case will have any precedent, but I do think it raises some interesting questions and issues, and it does underline once again, the importance of applying comparability factors correctly to both the taxpayer and the tax authorities. And sometimes those comparability factors can both be time and it can be geographical space. I hope you enjoyed this case. Till next time, bye for now.